started here in a minute. I'll say a few opening remarks and that'll give time for people to trickle in. Hi, for those of you that are already here, I'm Hillary Hallett, and on behalf of myself and my co-director, Samuel Roberts, and our associate director, Ty Jones, I'm very pleased to welcome all of you from the Columbia community, as well as our guests from elsewhere, to the Lehman Center for American History's first book talk of the year 2020. The Lehman Center for American History is a collaboration between the Rare Books and Manuscript Library and the Department of History. And we have dedicated all of our programming during this academic year to showcasing innovative scholarship that engages with contemporary issues of particular relevance to our historically charged times. In light of the events of the past year, my colleagues and I have framed our discussions around the themes of policing America, race, inequality, and health, and American politics, American identities. And for further information about our programming and for videos of all of our past events, please visit our new website, which our graduate intern, Isabel Plowright, will post in the chat. Izzy will also post the center's new Twitter handle. Please follow us there for more updates about our events and other news. So with the Supreme Court set to overturn Roe v. Wade nearing its 50th anniversary, we are delighted to have the nation's leading authority on the legal history of abortion in America with us today to discuss her most recent book, Abortion and the Law in America, Roe v. Wade to the Present, which was published right as the pandemic started last year by Cambridge University Press. Mary Ziegler is the Stearns Weaver Miller Professor at Florida State University College of Law, where her research focuses on the law, history, and politics of reproduction, healthcare, and conservatism in the United States from 1945 to the present. In addition to her most recent book that she will discuss with us today, Professor Ziegler is the author of two other books, Beyond Abortion, Roe v. Wade and the Fight for Privacy, published by Harvard in 2018, and After Roe, The Lost History of the Abortion Debate, also published by Harvard, which won Harvard University Press's Wilson Memorial Prize for the best first manuscript in any discipline. Professor Ziegler also regularly translates her careful scholarship to the public, so you may know her as a commentator in leading mass media outlets, including the BBC, CNN, NBC, the New York Times, NPR, PBS NewsHour, and the list goes on. So please join me in welcoming Professor Ziegler to the virtual Lehman Center. And please feel free during and after her talk to post your questions in the Q&A function that you see on this webinar. And we will turn to that. I'll look at that after her talk for our discussion. So thank you very much for joining us today, Mary. And I'll turn it over to you.
Thanks for having me, Hillary. So as is the case, I think, with many books, the idea for this book began with my first book. And I had done lots of talking to and studying people on either side of the abortion debate. And as I moved forward in time, I began to be puzzled by how many figures in the abortion debate weren't talking about what they seemed to care most about, which in the abortion conflict were the fundamental rights both sides see at stake in this conflict. So if you are opposed to abortion, you believe that there's a right to life in the 14th Amendment of the Constitution that entitles fetal life to due process and equal protection of the law. If you're pro-choice, of course, you believe that that very same 14th Amendment recognizes a right to choose abortion, at least up until the point of fetal viability. And I found over time that by the 1980s or 1990s, neither side seemed to be focusing as much on these constitutional rights, notwithstanding the fact that the rights themselves were as important as ever to both movements. And I think that remains true today. So that puzzle, the sort of why was I seeing more talk about what abortion in America is really like for people for people having abortions, for doctors performing abortions, for families of those having abortions, and for the communities in which they live. What was driving that? That was my first question. And what consequences did that change have, both for the politics of abortion and, of course, our national politics altogether? Because the abortion debate has very much been consequential to the alignment of our political parties, to our sense of the role of the judiciary in American democracy, and to much else besides. So the story began in the immediate aftermath of Roe v. Wade. Now, in the immediate aftermath of Roe v. Wade, the anti-abortion movement was in many ways unrecognizable to a modern audience. So the movement was not aligned with the Republican Party in particular, although there were certainly conservative abortion opponents. There were also abortion opponents who considered themselves progressive, or at least voted Democratic, or embraced certain policies like more robust protections against employment discrimination, or poverty policies that would help low-income people continue desired pregnancies. The movement was also more or less indifferent to the Supreme Court, which anti-abortion lawyers saw as a lost cause. After all, Richard Nixon, a Republican, had placed several justices on the court who had voted not only to strike down abortion restrictions in most states in the country, but to recognize a sweeping right to abortion. So while legal conservatives in general were just beginning to mobilize and to create an effort that would eventually lead to the Federalist Society, a group that would groom legal talent and attempt to create a conservative legal elite, the anti-abortion movement by and large wanted nothing to do with that and saw the courts as a waste of time. Instead, the movement was focused on a federal constitutional amendment criminalizing abortion coast to coast. So in progressive states as well as in conservative states. Here you have Senator James Buckley, the brother of famous columnist William F. Buckley, the sponsor of one of these constitutional amendments. Most of the amendments followed a similar theme, but the idea was to, as one activist put it, go above the Supreme Court's head, take the issue away from the courts, and really take the issue away from the states as well. The inspiration in part was the Equal Rights Amendment to the Constitution. So if at the time, it seemed possible to amend the Constitution to write sex discrimination out of American law, abortion opponents assumed that it would be possible to write abortion out of American law as well. But of course, the Equal Rights Amendment is not a part of our federal constitution, and neither is what abortion opponents would call a human life amendment. Amending the Constitution, it turns out, is virtually impossible, and all the more so when then, as now, most Americans did not support an outright ban on abortion, especially one that would apply nationwide. So abortion opponents began recognizing that at a minimum, these constitutional personhood proposals, they were federal personhood proposals, would take a while to pass. And so in the meantime, the young lawyers who were just flocking to the movement began looking for a way to keep the abortion rate down, or to at least limit access while the fight for a constitutional amendment raged on. And one of the men at the center of that effort was Henry Hyde, who you see pictured here. This is a more or less accurate picture of Mr. Hyde, who is more or less always on the phone. The Hyde Amendment, as his eponymous restriction would become known, began as a kind of relatively unimportant part of a relatively, what abortion opponents saw as unimportant effort that would serve as a stopgap while the constitutional amendment fight raged on. Hyde's amendment prohibited Medicaid reimbursement for abortions, and exactly which abortions would be contested over the years to come, but the basic principle would stay the same. The appeal of Hyde's amendment was that then as now, lower income folks were more likely to have abortions, and therefore limiting funding for abortion would likely have a huge effect on the abortion rate. As importantly, Hyde recognized that if you were allowed to limit abortion funding, the idea of a capacious right to choose abortion would become more incoherent. So at the same time the Hyde Amendment passed, other restrictions began to be introduced in states across the country, laws requiring the involvement of husbands, laws requiring the involvement of parents, laws requiring patients to hear disputed information before having an abortion. But soon the Hyde Amendment would come to mean much more. It turned out that passing the Hyde Amendment, even with exceptions for things like rape or incest or the health of the patient, almost eliminated Medicaid-funded abortions. The proving that you qualified for one of these exceptions turned out to be humiliating and onerous, and quite often legislators, Hyde among them, would argue that patients would simply lie about their circumstances to get abortions, which made those administering the law even more hostile. So the Hyde Amendment was a brilliant success from the anti-abortion movement standpoint, and soon they needed it to be. So, as I mentioned earlier on, the anti-abortion movement and the abortion rights movement didn't really align with either political party. In part, things were beginning to change in 1976. Gerald Ford very reluctantly ran on a platform that provided lukewarm support for the effort to ban abortion in the Constitution. Jimmy Carter ran on a platform that very lukewarmly described Roe v. Wade as the law of the land, but neither candidate really wanted to talk about abortion and took quite murky positions on the issue. That wasn't surprising because at the time there were both pro-life and pro-choice politicians in both parties. Thomas Eagleton, who was a prominent Democrat from Missouri, was one of the leading anti-abortion lawmakers in the Senate. Of course, Governor Rockefeller in New York was one of the most pro-choice politicians in the country and was actually responsible for vetoing an effort to reinstate abortion restrictions in New York in the early 70s. That had begun to change in 1980. So Ronald Reagan, in his ultimately unsuccessful 1976 presidential run, had courted the anti-abortion movement pretty heavily and endorsed a full-blown ban on abortion written into the Constitution. In 1980, when he became the party's standard bearer, he tried to use the abortion issue much more forcefully as a way to peel away Catholic and evangelical Protestant voters who might have voted Democratic, either for economic reasons or just because it was a convention in their region at the time. And Reagan was, of course, very successful in 1980, as were his colleagues, running with the support of the New Right and New Right Political Action Committee money. So for the first time, lawmakers who were openly opposed to abortion controlled both houses of Congress and the White House. As Dr. John Wilkie, who is the leader of the National Right to Life Committee, the largest national anti-abortion group at the time, put it, it was fantasy island come true. So it seemed that now was going to be the moment to pass this constitutional ban on abortion. But it wasn't easy even then. The movement didn't have the votes it needed to criminalize all abortions. And so the movement instead began what turned into a civil war about which alternative was best. So here, Jesse Helms, you see on this side of your screen the famous Senator No, who is primarily known for his racial bias and support of segregation, promoted what he called a human life statute that would recognize fetal personhood and thereby ban abortions. On the other hand, you had Orrin Hatch, this is a young Orrin Hatch here of Utah, a senator, who proposed a constitutional amendment that would allow but not require the states to ban abortion. The challenge, of course, was that neither of these measures really appealed to anyone in the anti-abortion movement. So Helms' proposal was great from their standpoint because it banned abortion, but it was probably unconstitutional. The Supreme Court allows Congress to enforce rights recognized in the Constitution, but not to define those rights for itself, especially in any kind of tension with what the Supreme Court has said. And Helms' amendment openly ignored Roe v. Wade, which had held that an unborn child or fetus was not a person. Hatch's proposal appealed to pragmatists, but of course it didn't require states to ban abortion. So the logical conclusion would be that many progressive states would not ban abortion, many purple states would not ban all abortions. And so absolutists in the movement saw it as Hatch's proposal as cowardly and pointless. Ultimately, neither proposal could command a majority in Congress, neither proposal could command a majority in the anti-abortion movement. And the anti-abortion movement's really reason for existence for the past decade or so ceased to be. And the movement's justification for aligning with the GOP as well. The reason for aligning with the GOP had been to put in place lawmakers who would vote for a constitutional human life amendment. So the question became, what is the anti-abortion movement going to do to eliminate abortion as it wanted to? And how could the anti-abortion movement justify its dependence on the Republican Party? And the answer, of course, came in the Supreme Court, and came in part with the Hyde Amendment. So the Supreme Court in 1980 upheld the Hyde Amendment, and that allowed abortion opponents to see that the Hyde Amendment may not be a stopgap, it may be a blueprint for a much broader plan of attack. So instead of trying to change the text of the Constitution, the movement would try to change the Supreme Court. So would seek to get Republicans elected to the White House and the Senate, to spend lots of money in terms of election spending to influence who those presidents and senators were voting on in terms of Supreme Court justices, and then to pass laws in the states that would tee up challenges for the Supreme Court, at least a reconfigured Supreme Court, to ultimately overturn Roe v. Wade. The challenge, though, of course, was that laws like the Hyde Amendment didn't really criminalize any abortions, and neither did many of the new restrictions that became popular after the end of the constitutional amendment campaign. These laws might in practice have made it hard to get an abortion, but they didn't, in effect, formally protect fetal life at all. So the movement had to come up with new arguments. So instead of talking about the right to choose or the right to life, abortion opponents began defending the merits of these restrictions, essentially saying these restrictions had socially desirable effects, and by extension, abortion itself had socially undesirable effects. And the most visible effort of this kind came in the epicenter of the universe in Akron, Ohio. No, it wasn't the epicenter of the universe, but it was for the anti-abortion movement. Akron had an ordinance that was passed with the help of most leading lawyers and professors in the anti-abortion movement. And the most prominent piece of this was a so-called informed consent law. The informed consent law required the patients hear information about the supposed risks of abortion, including things like infertility and depression, even though there was little or no evidence supporting any of those things. Again, the argument was not necessarily that there wasn't a right to abortion or that Roe was wrong. The argument was that Roe permitted these laws because abortion itself could be burdensome to patients or their families or their communities. And when the Supreme Court heard a challenge to this law, it firmed up even more abortion opponents' commitments to this new strategy, a strategy based on arguments about the reality of abortion in America and an incremental challenge to Roe. That was because of Sandra Day O'Connor, who I think my face is blocking here. O'Connor was despised by the anti-abortion movement during her confirmation hearings. She was viewed as a kind of sign of Ronald Reagan's betrayal of the movement. She was rumored to have been quite strongly supportive of abortion rights during her time in the legislature in Arizona. But when the Supreme Court weighed in on the constitutionality of Akron's law, O'Connor voted that Akron's law was unconstitutional, and moreover argued that Roe v. Wade itself was fundamentally unsound. She complained in particular about the idea of fetal viability, arguing that as technology improved, the date of viability would move up, and complaining as well that the Supreme Court was fundamentally unable to weigh in on medical or scientific questions when it lacked any kind of basic competence in either domain. So O'Connor's dissent convinced abortion opponents that it was actually possible to transform the Supreme Court and get Roe v. Wade overturned. And their efforts to focus on the reality of abortion in America had a lasting effect, as I'll discuss. Their efforts, I think, unquestionably drove the conversation about abortion over the past 5 decades. Quite often, abortion rights activists were responding to what the anti-abortion movement was doing, not the other way around. And they put at the heart of our conversations about abortion, not just the rights at stake, but also questions about what is fact and what is fiction, what is science and what is spin. And increasingly, as the decades continued, any kind of consensus about that, even if there had been very little to begin with, collapsed even further. And that made any kind of common ground solution, not only about abortion, but everything from maternal mortality to contraception, harder to find. So recognizing the idea that it was important to talk about the reality of abortion in America, anti-abortion leaders, while trying to change the court, began also focusing on laws arguing that abortion damaged the American family. Laws, for example, requiring minors to either get the consent of their parents or to notify their parents, which in practice amounted to the same thing. Laws requiring husbands to consent or be notified about abortions. And in service of these laws, abortion opponents argued that abortion was essentially damaging the relationships between teenagers and their parents, undermining the traditional sanctity of marriage, and as importantly, that many people having abortions were doing so for frivolous reasons. There were cases where anti-abortion lawyers argued that patients should only be able to have abortions for desirable reasons or socially beneficial reasons, rather than, as they characterized it, to look nice in a bathing suit in the summer. This had a pretty profound effect on the abortion rights movement too, in part because it was hard to argue against these laws. Then, as now, polling showed pretty strong support for laws requiring parental or spousal intervention. And the abortion rights movement wasn't really sure how to defend against these laws in a conventional sense. So often what they began to focus on was not on the idea of autonomy or privacy that had been at the heart of Roe v. Wade, but the idea of equality. Feminist scholars, of course, had been writing about the connection between abortion and equality for some time, but attorneys for groups like the ACLU Reproductive Freedom Project began to elaborate on and update these claims for the late 1980s and 1990s. So when talking, for example, about minors and abortion, these groups would explain that denying a minor access to abortion would quite often mean that that minor would lose out on opportunities to pursue an education or a career that were just becoming available to American women at that time. That argument was pretty powerful, and it would turn out to be more consequential than many had anticipated. So, of course, over time, the effort to shape the Supreme Court proved to be quite successful. And in 1992, the United States found itself in a moment very similar to the one we're in now. Republicans had created a 6-justice conservative supermajority on the Supreme Court, and that supermajority seemed poised to reverse Roe v. Wade. In 1989, that court had issued a decision that had called Roe's framework unworkable, and many believed that it was just a matter of time until Roe was overturned entirely. The court, in fact, actually took a case involving a Pennsylvania multi-restriction law involving everything from so-called informed consent to spousal consent. And in defending the law, most abortion rights supporters believed that there was no point to doing so, that in fact, eventually it would come down to politics, and the best hope was for a really spectacular defeat that would create a public backlash and a successful election. In case the court was inclined to hear an argument in favor of keeping Roe, though, abortion rights attorneys for groups like the National Women's Law Center and the ACLU Reproductive Freedom Project repurposed the arguments about equality that had emerged in fights about minors and abortion. So in asking why to save Roe, these lawyers argued not just that Roe was rightly decided, or that the right to privacy in general would be at risk if Roe was gone, but also that women in particular and all pregnant people had relied on Roe in ordering their lives, that their ability to participate equally in society, anyone who had the capacity to become pregnant, was conditioned on the availability of legal abortion. And that argument may have been the one that saved at least part of Roe v. Wade. So in 1992, the Supreme Court, many people don't talk about this, did overrule part of Roe v. Wade. So it overruled what was known as the trimester framework. Under Roe, at the outset, abortion could be regulated very little in the first trimester of pregnancy, could be regulated only for health reasons in the second trimester, and only after fetal viability was the state's interest in protecting life seen to be compelling, and it was only at that point that the state could regulate abortion to protect fetal life. Casey argued that that framework underestimated the importance of fetal life and that some abortion restrictions were appropriate. So it set out what it called the undue burden test, under which states could pass any kind of abortion regulation unless it had the purpose or effect of creating a substantial obstacle in the path of people seeking abortion. No one knew what that meant exactly, but it seemed to be a pretty forgiving standard because the Casey court upheld all but one part of the law in front of it, a provision requiring patients to notify husbands. That said, the court did save the idea of a right to choose abortion and did so partly based on the idea that patients relied on it. So conventionally, when the Supreme Court decides to overturn a decision, they can't do so simply because the decision is wrongly decided. There has to be some extra factor militating in favor of overruling. And the court will consider several factors in weighing that analysis. So for example, is a precedent unworkable? Have people relied on it in organizing their business affairs? And this reliance piece of the puzzle actually seemed tricky to some lawyers at the time, because usually when the court had talked about reliance, the court had done so in the context of things like contracts and business negotiations where there was lots of advanced planning. And of course, people who could become pregnant often did not plan to become pregnant at all when they pursued abortions. But the court nevertheless accepted arguments about the benefits of access to abortion that abortion rights attorneys had forged, and argued that abortion rights were necessary in part because patients relied on them to achieve equal citizenship. Casey, if anything, made arguments about the reality of abortion in America even more central for two reasons. First, of course, the undue burden test forced attorneys and activists and lobbyists and politicians to weigh in on what the real world effects of abortion restrictions were. That, from the standpoint of the anti-abortion movement, invited speculation about what the real world effects of abortion itself was. The second and related reason had to do with this idea of reliance. So groups like Americans United for Life and the National Right to Life Committee quickly recognized that Casey, the new decision, had saved abortion rights because patients relied on access to abortion to lead more equal lives. So those lawyers asked, what if we, the anti-abortion movement, can prove that abortion does not make anyone more equal? It in fact makes them sick and depressed and disconnected from their communities. And so that became the movement's new strategy, to overturn not just Roe, but Casey, by influencing the Republican Party in the Supreme Court, and to show not only that there was no abortion right in the Constitution, but that abortion had never benefited anyone at all. So there had been support groups for folks who had had abortions and regretted it for some time. You see here, Women Exploited by Abortion was one of those. And they've been around in the anti-abortion movement, but they hadn't particularly got a lot of attention, in part because the movement had come into being to fight for the rights of unborn children or fetuses, not of people who had had abortions. But after Casey, these groups took on new significance. And as they took on new significance, fights about the reality of abortion and just about the line between fact and fiction deepened considerably. So at first, abortion opponents tended to focus on restrictions exactly like the one introduced in Casey, but soon they pushed much further, and they began to make more and more contested statements in the laws that they were introducing. So for example, here you have Dr. Vincent Rue, or who was not Vincent Rue, wrong person. Here you have David Reardon's book. David Reardon was not a doctor or a scientist, but he had talked to lots of people who had been involved in anti-abortion support groups. And he published a book, Aborted Women Silent No More, that argued that abortion caused post-traumatic stress syndrome. There were other doctors, Joel Brind, who's actually pictured here, and other doctors who argued that abortion increased the risk of breast cancer. All of these ideas were written into abortion restrictions that were introduced in the States, even though peer-reviewed studies in both cases ultimately concluded that there was no evidence for either, or the best evidence did not support either assumption. So in Brind's case, the American Cancer Society, the National Cancer Institutes, and other leading organizations rejected the idea of a so-called abortion-breast cancer connection. That, of course, didn't convince abortion opponents to get rid of those arguments. Instead, what happened was that it deepened their sense that the medical establishment and the media had been corrupted by the abortion rights movement, and that any kind of traditional sort of mainstream authority had become unreliable when it came to the science of abortion or the facts about abortion. And so these groups began arguing that as long as there was any uncertainty, lawmakers should warn patients about the dangers of abortion and should trust abortion opponents themselves, who began, as in the case of Dr. Brind, to gather their own evidence, to start their own institutes, to publish their own studies, and to form a kind of entirely different knowledge community about abortion that was disconnected from the one in which abortion rights supporters lived. This campaign of sort of an alternative factual universe culminated in some ways during the partial birth abortion campaign of the 1990s. Partial birth abortion was a name that abortion opponents came up with for a procedure often called dilation and extraction. Here you have a graphic of dilation and extraction, which was a procedure usually performed relatively later in abortion, whereby a fetus or child would be removed in one piece instead of multiple pieces. Warren Hern, who is a doctor, was giving a paper on this at a gathering of the National Abortion Federation, and a copy of the paper leaked. Anti-abortion activists in Minnesota got a copy of it, created these line drawings, and began using it at the time to bludgeon those who were fighting for federal legislation protecting abortion rights. At the time, there was no prospect of a ban on this, but of course, after 1994, that was the so-called Republican Revolution. Newt Gingrich and his colleagues swept into office, and their priority became a ban on this procedure. Again, not because this procedure was common, not because it would prevent anyone from having an abortion, but because a ban on the procedure would lay the groundwork for discrediting the idea of abortion rights, would make it easier for Republicans to get elected, and would make it easier to change the Supreme Court. The problem, of course, was that the laws that this ban were modeled on lacked a health exception, right? So some groups, including the National Abortion Federation and Planned Parenthood, argued that in some cases, this was the safest procedure for patients because it involved fewer passes through the uterus with a sharp instrument. The response, as you may already have guessed, that abortion opponents gave was that the safety of the procedure was uncertain, and the need for the procedure was uncertain, and that when there was uncertainty, there should be more room to restrict abortion access. A federal ban on the law was signed into effect by George W. Bush in 2003, and a challenge went up to the US Supreme Court in a case called Gonzalez versus Carhart. Now, Gonzalez, I think, firmed up the idea that the difference between science and spin, or fact and fiction, would be at the center of constitutional conversations about abortion too. Again, the fight in Gonzalez turned partly on the lack of a health exception. The court did two things that were of fundamental significance. So first, the court picked up on an argument that had been made by David Reardon and others that abortion damaged patients' mental health. The court, in fact, relied on an amicus curiae brief submitted on behalf of Sandra Cano, who was the Doe and Doe v. Bolton, Roe's companion case, who, with other women, had submitted affidavits talking about the damage they believed abortion had done to them. The court cited this brief and said that while there was no reliable evidence to prove as much, common sense seemed to suggest that some patients would regret abortions, and that lawmakers could reasonably outlaw one procedure in particular to minimize the chances that women or patients would come to regret their own decisions. The court, of course, also had to grapple with the lack of a health exception, and ultimately decided that when there was scientific uncertainty, whatever that meant, that lawmakers should have more latitude to operate. Gonzalez then sort of wrote into constitutional jurisprudence these questions about what we mean when we talk about uncertainty, and how we identify bona fide science from ideological content, particularly when you're dealing with an issue as heated as abortion. In the aftermath of Gonzalez, the Tea Party wave happened. We have some Tea Party protesters here in 2010. The Tea Party was responsible for more anti-abortion legislation in the states than had ever been seen before, much of it, again, predicated on the idea that abortion should be banned or restricted, not simply because it violated rights, but because it was dangerous and harmful. And you began to see, too, connections between abortion and religious freedom, and a relitigation of the legality of contraception at the same time, too. So, for example, the anti-abortion movement had long stayed away from contraception as an issue, fearing that it would be used to brand the movement as a front for the Catholic Church. But during fights about the contraceptive mandate of the Affordable Care Act, anti-abortion groups used the idea of religious freedom to start talking about contraception again, and to problematize the line between contraception and abortion, in particular to argue that things like IUDs or the morning after pill were in fact abortifacients. It seemed to many that the Supreme Court would likely take some of these arguments to clarify that the undue burden test didn't really protect abortion rights at all. That was the expectation going into a 2016 case called Holman's Health versus Hellerstedt. That case involved two Texas laws, one requiring doctors to have admitting privileges at a nearby hospital, another requiring them abortion clinics to comply with the rules governing ambulatory surgical centers. If these laws went into effect, everyone agreed that all but a handful of clinics in the state of Texas would close, and that would make it difficult for some patients to get abortions in the first place. But a shorthanded court, Antonin Scalia had died earlier that year, surprised everyone, not only by striking down Texas's laws, but by giving new meaning to the idea of an undue burden, saying essentially that states had to prove not only that these laws wouldn't have devastating effects on patients, but also that these laws that they would take into effect whether these laws benefited anyone in the first place. So, for example, with respect to both laws, the court's majority said these laws are solutions in search of a problem. There's no evidence that these laws help any patients, or even that abortion is dangerous enough to warrant the laws being passed in the first place. Hellerstedt, of course, though, wasn't the last word, because Donald Trump surprised everyone, or not everyone, but surprised many, and got elected in 2016, and placed two new justices on the court by this summer of 2020, when the court took up a law identical to the one it had just struck down a few years earlier in Holman's Health, a Louisiana restriction that, again, required doctors to have admitting privileges at a nearby hospital. That case was called June Medical Services versus Russo. And June Medical is really kind of the final word we have on where the court is going now, and it's still very much a fight about the reality of abortion in America. So in the case, 5 justices voted that the law in Louisiana was unconstitutional, but John Roberts, who cast the deciding vote, the Chief Justice, whose vote is probably, or opinion is probably considered the binding law of the case, didn't join the majority's reasons for getting rid of the Louisiana law. He said, if anything, he would have liked to uphold it, and that his idea of an undue burden was much less robust than anything the Supreme Court had been saying recently, much less in 2016. And so Roberts, who wrote a lot about supporting precedent and admiring precedent, in the same breath partially reversed a precedent, and at least lower courts seem to think made it much easier going forward for abortion rights to be restricted in the states. With Trump's third nominee, we began to see, I think, a little bit of a turn away from arguments about the reality of abortion in America. Because, of course, as much as those arguments became central to our conversations about abortion, they in no way changed that either movement, the abortion rights movement or the anti-abortion movement, still had fundamental values and beliefs about what the Constitution said. When Amy Coney Barrett was confirmed following the death of Ruth Bader Ginsburg, the court again appeared to have what was a conservative supermajority, a kind of insurance policy, if you will, that if someone like Chief Justice John Roberts had second thoughts about overturning Roe because of a fear of a potential backlash or damage to the court's institutional legitimacy, Amy Coney Barrett or another conservative justice would still be there to cast that fifth vote to overturn Roe. You had already begun to see this shift in states in 2019 that passed so-called heartbeat laws that banned abortion somewhere between the 6th or 8th week of pregnancy. You began to see other states like Alabama and Georgia passing outright bans or personhood measures. And so there's beginning to be a little bit of a return to this clash of absolutes between rights to choose and rights to life that we've become so familiar with. But I think that doesn't change the significance of the time we've spent fighting about what abortion in America is really like. Because in some ways, I think abortion became a kind of canary in the coal mine, in the sense that it both reinforced and reflected some of our collapsing consensus about lots of public health questions and who has the authority to weigh in on them, collapsing consensus about the role of the press as a truth teller. And of course, with respect to abortion itself, our deepening polarization, not just about abortion, but about issues related to it. So how did this deepen polarization? You began to see groups on either side not just disagreeing with one another about what the Constitution ought to mean or what the vision of the good life looked like, but also just about what was true and false. So instead of simply viewing someone on the opposing side as wrong, you would also view them as fundamentally dishonest, deluded, or manipulative, which made having conversations about something as basic as the United States' disturbingly high rate of maternal mortality, particularly for Black people, seemingly politically impossible. So I think I'm curious to see what comes next, and we can talk about this in the Q&A too. I think there's a sense of deja vu in more ways than one, because the anti-abortion movement seems to think that the Supreme Court can put an end to this conversation by overturning Roe. And if you learn anything in studying this issue, it's that the Supreme Court, of course, has failed spectacularly to put an end to this issue in Roe, which was what Harry Blackmun believed he was doing all those years ago in 1973. He had a news clipping suggesting that large majorities of Americans thought that abortion should be a matter between a woman and her doctor. So nothing the court can do will put an end to this. And I think only time will tell what will happen. I think we'll see state by state conflicts. And I think we'll see the Supreme Court continue to be at the epicenter of the conflict, even in a post-Roe world, should we ever get to one. So I'll stop there so we have time for Q&A. But thank you for listening.
Thank you. Thank you, Mary. If we were all in person, we would now be clapping and, and you know, able to more directly express our gratitude for your joining us and for your talk. Folks can put their questions into the Q&A if they have them now. We're waiting that, and maybe while folks collect their thoughts, I'll start off. I'll take the opportunity as the leader here to ask a question. So I wanted to know, first of all, I love the way that your book goes back and forth between each side. You know, even on the same page. That's such a very challenging thing, I know, to do when you're writing about the history of any kind of social movement, and it's not done that often actually in history. People tend to study one side or the other rather than trying to do both at the same time. So I was really appreciative of that. I couldn't think of another book on abortion that I'd read that did that so well. But in covering so much ground, there, you know, there's a lot there, obviously. And I wanted you to tease out for us, I hoped you could tease out for us a little bit more about the racial politics of how this is playing out. You know, you tell us that before Roe, anti-abortion folks mostly linked the procedure to eugenics pretty successfully, to eugenic measures and population control. And then from what I could gather, right, that starts to change slowly after Roe, and more African Americans come to support abortion, right, as they're pressing for its inclusion in a broader kind of conversation about reproductive justice and health. But you also note these moments of failure where it seems like the largely white-led, largest organizations in the pro-abortion movement, let's just say, do things like they impose consent restrictions for sterilization, for fear that it's going to lead to more restrictions on abortion. And so I was just hoping that you could say more about how the divisions, specifically, I guess, within the largely white-led pro-choice movement, but it seems like both sides are largely white here, but how much, a broader emphasis on reproductive health versus a single emphasis on abortion, is affecting the way that the racial politics of this are playing out.
Yeah, I think that's absolutely right. I mean, both movements have been, and I think even to some extent still are, although that's changing predominantly white. Ironically, though, because I think both movements saw themselves as carrying on the tradition of the civil rights movement, right? I mean, the anti-abortion movement claimed early enough on to be the kind of the next abolition movement, right? So they compared the sort of protection of the unborn child. The 14th Amendment, they were saying we're kind of treating unborn children as persons in the same way that slaves needed to be treated as persons. Then when they focused on the court, they were saying we're the next NAACP, right? I mean, we're doing the next Brown versus Board of Education and school desegregation. And that was very much true of the pro-choice movement too. I mean, Betty Friedan's famous speech was called "Abortion, a Woman's Civil Right," right? So this was, both of them were making claims on that tradition, but ultimately often unsuccessfully. I think part of that was because abortion became a political party issue, right? And it became an election issue. So you would see, particularly on the pro-choice side, groups saying, well, it's true that the people who are having the most abortions tend not to be white, and they tend to be poor. And they tend to be the most affected by laws like, say an informed consent law or the Hyde Amendment. But our donors don't care about those things because our donors are not low-income people of color. And politicians don't care about those things because politicians don't care about low-income women of color or people of color at all. So we're going to go with the things that our focus groups and our polling and our political allies tell us will be the most effective, which tend to be bans. And I think that's still true now, I think. There was much more, in my experience, energy around the 2019 laws in places like South Carolina and Alabama than there's ever been about the Hyde Amendment. I think what changed largely was that reproductive justice advocates, largely people of color who sometimes had worked within the larger pro-choice organizations, but often who had formed organizations of their own, gained enough power both within the movement and within the Democratic Party to make that kind of poll-driven approach politically untenable. But that happened quite late, even though the reproductive justice movement as such had kind of burst onto the political scene in the 1990s. The abortion rights movement, especially the larger, more organized, more DC-connected groups, at most used that rhetoric without a lot of care to the actual priorities of the groups and the individuals who had pioneered it. I think that began to change much more visibly in 2016. Hillary Clinton was the first Democrat to run on a platform that actually opposed the Hyde Amendment. And you see it much more clearly now. But I think there were lots of moments when the pro-choice movement, I think, deliberately made strategic choices that would downplay or sideline the concerns of people of color and low-income people in the name of saving Roe, right? So there's a long-standing conversation about, has Roe been good or bad for the pro-choice movement? And of course, the answer is yes, right? I mean, it's both. But I think one of the costs of Roe has been the pro-choice movement's willingness to sacrifice almost anything in the name of preserving it at times, including the priorities of people who were the most affected by the restrictions that were getting introduced.
Right. Okay. Yeah, great. Okay, so I've got some questions. Yes, and folks, please feel free to put the questions in the Q&A, not into the chat, please. So Ty, one of our other directors, has this to ask. He says, this might be reductive, but we often think of progressive organizing as a largely grassroots phenomena, whereas conservative activism follows an astroturf model where wealthy organized donors operate behind the scenes of the movement that presents itself as populist and grassroots. Does the anti-abortion movement complicate this picture, or do you think it can be described in these terms? If the latter, how do you explain the success of anti-abortion activists in keeping pro-choice groups in a reactive posture?
It's that's complicated. I think early on, the anti-abortion movement very much was an exception to that. The conservative legal elite wanted nothing to do with the anti-abortion movement and largely thought of the movement as being kind of crazy people you didn't want in front of a microphone. The organized religious right, which was distinct from the anti-abortion movement, obviously more conservative on more things, tended to be more evangelical than Catholic, forged a partnership with the anti-abortion movement, but was sometimes uncomfortable with some things the anti-abortion movement wanted to do. And the Republican Party was, of course, happy to have anti-abortion folks present, like Paul Weyrich and others wanted anti-abortion voters there. But anti-abortion groups themselves didn't tend to have a lot of money at all and tended to have to depend on other groups with connections to wealthy donors. What began to change over time was that anti-abortion leaders became more involved in Republican politics and ironically became quite interested in the issue of campaign finance. So Jim Bopp, who's the main character in my fourth book that I'm writing now, became convinced that the only way to overturn Roe v. Wade was to deregulate campaign spending, both because that would allow abortion opponents to spend as much as they wished, but also because it would make the anti-abortion movement much more valuable to the GOP. And so Bopp over time became kind of one of the go-to lawyers for people who wanted to create dark money organizations. And then, of course, the anti-abortion movement forged much closer connections to some of the wealthy donors who make up, at this point, almost half of our election spending is by the top 0.1%. And those people have very close ties to abortion opponents and their organizations. But that was a relatively recent phenomenon that was, I think, actively the work of abortion opponents who realized that they still were disconnected from the sources of power in the Republican Party. Of course, I think, in forging those connections also helped to sort of destroy parts of the GOP establishment and give populist elements of the party more purchase or more ability to bid for power in the party. But that was a recent phenomenon. The early movement was financially dismal most of the time. Like the richest, largest organizations were often in such debt that they almost had to close their doors. So it was populist movement until it wasn't.
Right. Okay, great. So this is from Christopher McKeon. You mentioned the effort to stop abortion through a constitutional amendment and now through the Supreme Court, but why hasn't there been as strong an effort to promote adoption? If you can't stop abortion, why not make another better option?
Yeah, I mean, I think broadly speaking, you could even expand that question to ask why has there not been more focus on the reasons that people pursue abortion, right? I mean, so not just adoption, but the circumstances that make people who might want to continue a pregnancy feel they have no choice. Everything from, discrimination at work to lack of access to sex education and family planning to just things like a living wage or safe housing. And the short answer has been, with respect to adoption, I think that's the trickiest piece because pro-choice groups have often said adoption isn't really a valid alternative because people would still have to be pregnant and pregnancy itself raises all kinds of issues, including dangers for patients. Abortion opponents, I think, have never been as comfortable with adoption as an alternative because many of them believe, along with attorney Harold Cassidy, that and I'm going to say this in gendered terms because this is what they believe, that women form bonds with their unborn children during pregnancy, and that there's a fundamental right at issue there for women to continue that relationship. And so they often see adoption as much as abortion as being sort of unnatural. But part of it, I think, is also due to the fact that the anti-abortion movement does rely on the Republican Party so much to shape the court. And the Republican Party, of course, has no interest in the kinds of solutions that would reduce demand for abortion, whether that's more robust employment discrimination protections or a broader social safety net. So that means that the movement has had little political choice but to focus on access rather than demand. Of course, I think that'll eventually become quite problematic, because if Roe is overturned and states like Alabama have criminalized abortion as much as they can, abortions will continue unless there's more done with the demand side, which I've seen very little sign is happening.
Right. Yeah. So I have a question for you that's a little bit broader, but because you do so much public talking about this, I wondered, how, perhaps, certainly among the most polarizing issues in political life right now, and you're such a public face of sort of translating this very careful scholarship to the media, what kind of strategies do you use to try to maintain, a kind of academic legitimacy in a subject rather that doesn't seem to admit, even basic medical facts, like the fact
Yeah.
that, pregnancy is more dangerous in the United States than abortion.
Right. Yeah. I mean, I think it's hard, and it was harder with this book than with earlier books. I think that I want to. I mean, I'm concerned about polarization in this country, and I'm concerned about the sort of rise of alternative facts generally. And so I'm trying to write things, whether I'm speaking to the public or I'm writing for an academic audience, that people will read who don't agree with me, right? I mean, I don't think, I mean, it's great. I want people who agree with me to read my stuff too, but I'd like for everyone to see that this is a problem, right? Including people who don't consume the same sources of information and don't believe what I believe. And so I think I'm trying to model kind of respect and letting the reader judge for themselves. I think from the standpoint of, I don't know if you need me to jump in and say this assertion of fact is ridiculous. If I tell you that, these expert organizations that know much more about breast cancer than I do say abortion doesn't cause breast cancer, I then don't need to intervene and say, and the people who are claiming otherwise are terrible liars. Like, you can form your own opinion. And I think also, to some degree, that kind of conscious editorializing kind of performs the sort of polarization I wanted to avoid. I also sort of see my role as a historian as being unusual in the sense that there are a lot of really fantastic historians who are also advocates, right? Who write in this space, like Linda Gordon and others. And I think that's admirable, but I think there are a lot of people who are already doing that well. And so being able to write about what's happening in both sides and then letting readers see for themselves what can be going wrong with that, including people with whom I agree, right? I think is something that there isn't enough of in history, and that's a gap I try to fill. And the same thing with public writing. I tend to be writing op-eds or talking about how we got here without telling you whether here is good or bad. Because I think if there's any topic in America where everyone already has an opinion, it's abortion, right? You really don't, if all I did was offer an opinion, there would be no need for me to ever write another word, because there are plenty of people who are brilliant who are already doing that all the time.
Right. Yeah, that makes sense. So I have another question. In light of the recent legalization of abortion in Argentina and Ireland, where does the United States legal battles about abortion fit into broader international context? Is the United States representative or an exceptional case in terms of countries who have legalized abortion that has sustained a strong, organized pro-life movement?
It's hard to say, right? I mean, Ireland is already starting down somewhat a little bit of the same road. The anti-abortion movement is international, so this isn't surprising. So for example, in Brazil, there's an organized anti-abortion movement that uses a lot of the arguments and tools and rhetoric of the American anti-abortion movement, which has short-circuited efforts to change the law on abortion in Brazil. And there, of course, I don't think there's a clear trend, right? So we have at the same time Argentina and Poland, right, which of course is through kind of illiberal courts introduced more and more onerous restrictions. So there may be a kind of common theme there in the sense that courts are not really reliable one way or another, because we've seen in recent years courts in South Korea and Kenya expanding access to abortion, in courts in places like the United States and Poland contracting it. So I think one of the sort of strange things about the international picture is how often courts in other jurisdictions still cite and rely on Roe. Roe, not even Casey or decisions interpreting Roe, but Roe itself. And so Roe has continued to have this kind of almost magnetic effect in other courts, notwithstanding criticisms of it. And so probably the most concerning thing about that is that in some other jurisdictions, courts may look to what's happening in the United States and make decisions on that basis, because Roe has always played, I think, a kind of weirdly central role in a lot of countries' jurisprudence, even though critics in the United States, really across the ideological spectrum, have long said that Roe is not, the final word in United States constitutional jurisprudence.
Right. Yeah, well, sort of following up on this, I mean, so, and this is something I was wondering about. Mike asks, public opinion has moved dramatically in recent years on many issues. An example would be gay marriage.
Right.
Now has wide acceptance. Why has the abortion divide, remained so static, it seems, right? That with most public opinion and polls largely on the just general question remaining almost unchanged over this whole period.
Yeah, it's hard to say. I mean, I think abortion, one of the things that's striking about abortion polling when you dig into it is how similar US abortion polling is to polling in most of Europe, right? Which is to say that a lot of Americans are not in the kind of viewing abortion as a moral good camp, often are morally troubled by abortion, but also equally or more troubled by criminalization, especially early in pregnancy. And so I think part of what's happened is that there's been a kind of really profound disconnect between abortion politics in the United States and abortion, the views of Americans on abortion. So Americans themselves seem to want something like what you would see in lots of parts of Europe, in the sense of broad access early in pregnancy and less access later in pregnancy, probably not with funding, because Americans tend to be less supportive of a kind of welfare state than many Europeans are. But I think because of that disconnect, there hasn't really ever been an effort by either political party to go where popular opinion is. Instead, often you see both parties appealing to the people who care most passionately about these issues, which tend to either be people who want abortion to be illegal under all circumstances or legal under all circumstances, and not the vast majority of people who find themselves kind of confused by the issue and somewhere in between. And I think some of that is just because abortion is a complicated issue. I mean, it's often very informative to talk to people who perform abortions, who often view abortion as a complicated issue as well as a fundamental right and a fundamental health service. So I think that's probably part of it too, that it's something inherent to the issue.
Right. So another question. First of all, I just wanted to mention that someone, Christopher McKeon, wanted to just comment that he really appreciated your non-polarizing presentation mode, and how refreshing that is and needed, as well as responsible. So, as an author, how do you write? Okay, so sorry, I started a little too late. Something that strikes me about the pro-life movement is its heterogeneity. As an author, how do you write a nuanced account of a social movement that attracts people from across the social political spectrum for various reasons?
Yeah, it's hard. I mean, I think what I've tended to do, and this is sort of about letting, when you spotlight particular characters versus organizations or, the movement, right? So I tend to try to have, particularly when you're talking about heterogeneous movements, to kind of tell the stories briefly of people who are, from different wings of the movement, or who came to the movement from different experiences or backgrounds, just to remind people of that. And then, of course, I mean, there are moments when just you have to narrate it too and say that there were internal disagreements about various things. But I think it's important too, I think, to actually let activists themselves speak sometimes, like you use their words and their stories and not just have me tell you what they're trying to say. In part because I think when I first started studying this, I have people who are pro-choice and pro-life in my family, but not my nuclear family. And I really hadn't talked to people often who believe certain things at any kind of length. And when I did, it was easier for me to understand not necessarily the substance of their positions, but how they arrived at those positions. And so when I write about characters and movements, I often try to do that too. It's harder at times because some of the people I write about I don't find sympathetic, and I try my best to empathize and to kind of reconstruct how they got where they are. That's not always that easy to do, but I think that's important often to let people speak for themselves, and often sometimes even to use their language, which is another tricky thing for historians writing in this space. You know, do you say, for example, I would never say anti-choice, right? Because that's very much a like my opinion kind of interjection. I would prefer to say, to use people's own language and to describe people as they see themselves, and then to let readers judge whether that language is apt or appropriate rather than my making that choice ahead of time.
Right. Yeah, no, that makes a lot of sense. Um, so I think we've got time probably for a couple more questions. If folks have them, please put them into the chat. I just wanted to return a little bit up to this point about the difference between the massive kind of move in public opinion and support for gay rights versus this kind of stable picture, that you've described with respect to abortion. And one of the things that strikes me is that on the one side, there is definitely this perception that, the media, the liberal mainstream media is sort of pro-choice.
Mm-hmm.
On the other side, one thing that I'm struck by as a scholar of media is how there are almost no representations in mainstream media of the choice to have an abortion.
Mm-hmm.
And so I feel like most of the representations that do make their way into mainstream media actually, make the other side's position clearer, right? The whole abortion is murder, and the pain, as you have in your book, the silent scream video that was so influential in popular discourse. So I'm wondering, do you think that some of that just has to do with the difference of sort of coming out as having an abortion versus coming out as, being, not heterosexual? Is one a narrative that, people, then incorporate you, they see you in their family, they see you in their community, and that's something that brings sympathy, whereas the other, it doesn't not exist at all. I know that, pro-choice folks have at times, tried to encourage women to talk about the difference that decision makes in their lives. But how do you account for sort of that how would you explain that really different description of these kinds of events in mainstream media?
Yeah, I mean, I think the anti-abortion movement's been very successful in stigmatizing abortion, and for some reasons that the anti-abortion movement controlled, and for some reasons they did not. So in the 1970s, before Roe, right, a lot of abortions were performed by doctors, right, either in doctors' offices or in hospitals. They're still performed by doctors, but they were performed in places where lots of other medical procedures were done and where abortion was a small part of practice. Immediately after Roe, there were no abortions being performed in lots of southern and midwestern states. I think in the state of Mississippi, there were literally 0 abortion providers, which is not that surprising. But so what you began to see groups like NARAL and other pro-choice groups doing is saying that there needed to be freestanding abortion clinics that would guarantee access to abortion. So very quickly, what happened was that almost all abortions were being performed in freestanding clinics. Some of them were feminist clinics, some of them were not. Some of them were Planned Parenthood, some of them were not. But in many cases, those became associated just with abortion. And abortion, in turn, became associated with not necessarily being a medical service, but being a moral issue or a rights issue. And I think that made it a lot easier for abortion opponents to stigmatize abortion, both because of the optics of being in a separate facility and even the practical effect of being in a separate facility, which made it much easier to protest those facilities and blockade those facilities. I think there's also been a lot of successful work by abortion opponents of leveraging discomfort with later abortions to be where almost all the imagery comes from. A lot of the advocacy too centers on later abortions. And that's made it uncomfortable for people to talk about abortions. I think the abortion rights movement not only had a role to play with respect to the creation of independent clinics, but also some of the language around privacy and autonomy has made it hard to talk about abortion as something that isn't private or that you should broadcast or talk about comfortably in public. I think, of course, too, there's often finally, I think, a role played by the fact that this has a lot to do with courts and litigation, because often the people who are called upon to share their stories about abortion are people in states with the most onerous restrictions, in communities where abortion is the most stigmatized and where being open about having had an abortion could potentially have the most devastating consequences. So I think all of those things have made it quite stigmatized to have an abortion. And there are also many Americans who personally are not comfortable, like, or don't feel great about the idea of abortion, but still want access to the procedure, right? Who see it as a sort of unfortunate necessity, the kind of Bill Clinton era, you know, safe, legal, and rare. People have internalized that, and there are lots of voters, I think, who fall in that part of the spectrum who are uncomfortable talking about it for that reason. But I think certainly the stigma itself is not something that's naturally occurring and has been the product of lots of years of movement work.
Right. Yeah, that's great. Okay, well, thank you so much for joining us, Mary. We really appreciated your talking with us about this most recent book and the answers to the questions. So now I'm going to give you, everybody can you were here, we'd be able to, you know, again, express our gratitude more directly, but please accept it virtually on my behalf.
Yeah, of course. Thank you so much for having me. This was a lot of fun. Hopefully we can do something at some point in person.
Yes, I really hope that. Take care.
Okay, thanks.
Bye, everybody.
Bye.